Hello and welcome back to Coin Lady channel. The money isn't the only factor. However, at its core, the issue is one of commercial wiring and the internet. The dispute between Ripple and the US Securities and Exchange Commission has been going on for quite some time. What do you anticipate the outcome will be? After 2 years of litigation, the public is eager to learn the outcome of the dispute between the fintech company and the SEC. The question is, how and when will it end? At this moment, all eyes and ears are trained on Judge Annalisa Torres of the Southern District of New York for any word on the outcome of the protracted case in the cryptocurrency industry. As the culmination of the SEC's litigation against Ripple draws near, many in the XRP community have begun making educated guesses as to the outcome. Others predict the blockchain startup will lose its case against the SEC, while XRP enthusiasts are optimistic that a complete victory is conceivable. Whether XRP, the crypto token on which Ripple services are based, is a security, a tradable financial instrument like a bond or derivative, or something else entirely is at the heart of the suit brought by the SEC, which has asserted its jurisdiction over cryptocurrencies by filing the charges. If the court determines that XRP is a security, then virtually all other crypto tokens would also be securities and be subject to regulation by the SEC. Companies dealing with cryptocurrency would be subjected to onerous registration and reporting requirements, and businesses that issue tokens or facilitate the trading of tokens without SEC approval could face legal repercussions. There is always the risk that even major US-based exchanges will become targets. According to defense attorney John Deaton, who testified as an expert witness for XRP holders, this would be devastating for the cryptocurrency industry. The question of whether crypto assets should be considered as securities must be reviewed on a case-by-case basis through the application of the Howey test due to the lack of legislation that makes explicit the categorization of crypto assets in the US. The SEC's charges against Ripple and its officials said that the company had broken federal securities law by soliciting investors to purchase XRP. JV the Great, an XRP supporter, recently started a Twitter discussion in which she and her fellow skeptics claimed that all XRP transactions conducted by Ripple should be considered securities. Because the blockchain startup did not present a compelling argument against anything besides the blue sky rules, he was confident that Ripple would be unsuccessful. In response to the JV the Great rumor, crypto law creator attorney John Deaton made the XRP community happy by tweeting an explanation of how Judge Annalisa Torres might rule in favor of Ripple. Deaton elaborated that he doubts Judge Torres would side with the blue sky argument, but that Ripple still has a shot at beating the SEC and ending the protracted court battle that has lasted over 2 years. Since the SEC does not apply the Howey test to all transactions, Judge Torres, according to Deaton, could circumvent the sale of Ripple's XRP. Instead, the authority asserted that XRP itself constitutes a security. The SEC is using the all but for causation test here, arguing that if it weren't for Ripple execs like Jed Chris inventing XRP, the cryptocurrency wouldn't exist. However, XRP secondary market would not exist without Ripple's assistance. Without the SEC's position that all XRP sales, past and present, are securities, the secondary market, according to attorney Deaton, would not exist. The authority claims that XRP efforts are the sole reason why countries other than the US have recognized it as legal tender. Deaton added that if Judge Torres were to rule against the SEC's broad accusations on the grounds that the regulator failed to prove a specific transaction, it would amount to an overwhelming victory for Ripple. In other words, the SEC is asserting that all of Ripple's past, present, and future efforts would have been for naught had El Salvador made XRP legal tender like it did with Bitcoin. It's a fantastically comprehensive theory, but it's not how securities rules are typically enforced in practice. The lawyer representing the XRP community criticized the SEC for being inconsistent in applying the Howey test's common enterprise requirement. At first, the SEC defended Ripple as if it were a typical business. One of the regulator's experts later testified that the entire XRP ecosystem, including XRP holders, exchanges, and independent developers, comprised the common enterprise, and the regulator subsequently reversed its position. In the face of repeated pushback from the XRP community, the SEC decided to drop the expert's testimony. Instead, the SEC claimed that XRP stands in for the entire business and that it symbolizes every pledge and effort made by Ripple. According to Deaton, the SEC has argued that XRP passes the Howey test's second and third requirements. Deaton thinks Judge Torres would not grant the regulator summary judgment in the way they ever sought because of the SEC's argument concerning XRP. Meanwhile, Deaton speculated that both Ripple and the SEC's summary judgment requests would be denied by Judge Dorr, sending the matter to a jury. Moreover, he said, some have failed to take into account the possibility that Judge Torres would rule against both parties' summary judgment motions, sending the case to a jury. However, I will not be able to make any firm predictions until I have seen all of the Rule 56 facts and all of the underlying evidence relied upon. According to critics, the SEC is trying to change the law in ways that are unconstitutional. It is important to recall that the SEC itself recognized in its response to my petition of mandamus that the court must evaluate whether or not the SEC's approach is valid. As for the SEC's sweeping notion, I have faith that the judge will rule against them. It's worth noting that in February, Stewart, Ripple's chief legal officer, predicted that his company would win the case against the SEC's claims that its XRP, a cryptocurrency, could be considered a security. In a tweet, he claimed that those few who had the guts and means to stand up to the SEC had resulted in the SEC losing 4 of its previous 5 cases in the Supreme Court. He's abusive, insisting on stretching the law to fit his preconceived notions. The internet company's leadership had previously expressed optimism that the case before Judge Analisa Torres of the United States Southern District Court of New York would be resolved quickly, so these new statements came as something of a surprise. Prior to then, Brad Garlinghouse, CEO of Ripple, had told CNBC, "We're optimistic that this will certainly be resolved in 2023, and maybe in the first half. From here, we'll have to observe what happens. But I'm confident in where we stand legally and factually, and I anticipate a verdict in the Ripple litigation to be given down in the next months." To settle down, however, takes one very vital factor, as Garlinghouse pointed out. Furthermore, going ahead, it is obvious that XRP is not a security. The SEC and Gary Gensler have gone on record as saying they consider virtually all crypto to be securities. As a result, there is barely any overlap in the Venn diagram to accommodate compromise. Due to the far-reaching ramifications of the verdict for the whole cryptocurrency business, the entire crypto community has been on edge while waiting for the court ruling on the issue. The SEC has been fighting for crypto regulation, and a victory in this case might pave the way for more actions. If the Commission is successful in labeling XRP as a security, it will have authority over a wide range of crypto assets and certain areas of the crypto industry. If the SEC prevails, the Commodity Futures Trading Commission (CFTC) may be given the authority to regulate crypto derivatives and trading under a bill submitted by Senators Cynthia Lummis and Kirsten Gillibrand in June 2022. Johnny Deacon's several cogent arguments have been made in recent posts about why the outcome of this case could have far-reaching consequences. According to him, international holders have been left in the dark because few judicial decisions have the capacity to affect not only the United States but the entire world. The vast majority of court decisions don't have the potential influence on the United States and the rest of the globe that this one might. There have been 17 amicus briefs filed on behalf of international holders at the district court level, etc. According to Deaton, virtually all prior judicial decisions were meaningless and irrelevant. In light of his recent remarks, Deaton believes Judge Torres will rule that secondary market transactions involving XRP are not securities. Do you have an opinion on the judge's decision? When do you think the judge will hand down his decision? It's all over today. Please like and subscribe my channel. See you later, bye.